Today we are talking about one of the more recently spoken about trademark cases to come out of Australia, that being the one between Australian fashion designer Katy Perry and Katy Perry, the American pop star that we know and love. The case is Taylor and Killer Queen LLC, and the decision was made very recently in the High Court on the 11th of March of this year.
I think for today's purposes, why don't we call them Australian Katy and Popstar Katy?
If we have a look at the parties, we have Katy Jane Taylor, who is an Australian-based fashion designer. Now, she started selling her clothes, which were luxurious loungewear, from 2007, and she registered her name in 2007 and went on to sell her items in showrooms and at the Rocks, and then decided to trademark the name Katy Perry,
Which was her birth name.
Which was her birth name, exactly, except spelt Katie, which is different to the pop star Katy. And she did this in 2008, where she trademarked it for the purposes of clothing.
Okay. And then Popstar Katy Perry's trademark is registered in 3 different categories, one being music, one being entertainment, and the third, the most important one, also being clothing. And this is class 25. And it is in this class that Australian Katy Perry had already sought to register her own trademark, which was very similar, just the Katy spelled differently. Now, because Australian Katy Perry also essentially got there first, Popstar Katy Perry did withdraw her application to register her trademark in the clothing category and kept her 2 trademarks in the music and entertainment categories on foot. However, she still did challenge the validity of Australian designer Katy Perry's initial trademark, essentially saying that she had this big reputation already in the field. And there was a bit of a legal fight just then around 2008. There were cease and desist letters being sent by Popstar Katy's team to the Australian Katy Perry. And there was a formal opposition process that was initiated, but ultimately Australian Katy Perry's trademark was formally registered in the clothing class. And then all was quiet for about 10 years.
Right. So if we fast forward and have a look at 2019, between that period, Popstar Katy Perry had been selling her merchandise, selling her goods with Katy Perry, despite the trademark that Australian fashion designer had registered in 2008. So what she did in 2019 was commence infringement proceedings against Popstar Katy Perry for using this term she had already trademarked. With those proceedings on foot, we had Popstar Katy Perry then file a cross-claim against Australian Katy Perry, and she put forward 2 arguments. The first being that at the time that Australian Katy Perry registered the trademark in 2008, Popstar Katy Perry was already well known and she was famous and people recognized who she was.
So that led to confusion in the marketplace, which is the important question for the courts in all of the decisions that we're going to talk about today. The question is the average consumer potentially confused by how similar those 2 trademarks are at the time?
The second argument put forward was that even if she wasn't recognizable in 2008, by December 2019, she had just performed the Super Bowl and she was 100% recognized internationally. So there was definitely going to be that confusion, or so they allege.
So at first instance, the trial judge found in favor of Australian designer Katy Perry. So it was a win for the Australians. And they even went as far as to award damages for how extensive the copyright infringement was, because Popstar Katy Perry had been selling merchandise this whole time in this 10-year period. And a really key part of that first instance decision was for the whole decade that we had Australian designer Katy Perry's trademarking clothing. We also had Popstar Katy Perry's 2 trademarks in music and entertainment. Neither of the parties could show that there was one instance of a consumer being confused between the products sold.
So nothing was documented?
No. So because we're concerned about whether the average person is confused by these 2 trademarks. There wasn't. There were enough differences between the way that the trademark was used in the clothing category and the way that the slightly different trademarks were used in music and entertainment. However, Pop star Katy Perry then appealed the first instance decision to the federal court, and the federal court found in favour of pop star Katy Perry and overturned that initial decision in Australian Katy's favour. A big part of the reasoning at the federal court level was that it was such a common practice for pop stars, musicians to sell merchandise and different clothing and apparel items alongside their goods and services in the music and entertainment industries. And because of this common practice of selling merchandise, Katy Perry's reputation, her trademark, extended into the clothing class back at that really crucial time in 2008. So it's essentially patching the gap and making an argument that even though pop star Katy Perry hadn't been selling clothing or merchandise back in that time, back before 2008, her reputation of the other two marks was so distinct and was so worldwide that reasonable confusion could be caused.
So Australia, Katy Perry, obviously disappointed in this decision, went and appealed it and took it to the High Court, which, as we know, will have the final say. Now, they actually overturned the federal court decision, reinstated the initial decision, which was found in Australian Katy Perry's favour. Now, what they said is that irrespective of the name of Katy Perry now, back in 2008, when the trademark was registered, not a single item of clothing had been sold in Australia that related to pop star Katy Perry. And it was a big win for small businesses and small people, because what that meant was just because somebody has a name and has this presence and platform, it doesn't mean that they can override your trademark, which was made prior to, this presence that they now have.
And I think a big question for the High Court to decide upon was, do we look at Katy Perry's reputation and stardom holistically across different classes of goods and services, or are they required to look at whether she had such a reputation in clothing in that specific class back in 2008 to warrant the cancellation of Australian Katy Perry's initial trademark? And they didn't find that that was the case. The High Court wasn't as persuaded by the common practice argument that pop stars will just inevitably sell merchandise and their sort of stardom and reputation in their respective industries carries over to the clothing category. They were saying, no, not one piece of clothing with pop star Katy Perry's name was being sold prior to the important priority date in 2008. And that was what was really important here. Her figure, her stardom in music and entertainment did not carry over to clothing.
And I think it's worth calling out that Australian Katy Perry's representatives mentioned or spoke to the fact that pop star Katy Perry had such a presence that it shouldn't have been confusing. And that's what we saw. There was no confusion. So her name was that large, or if it was as large as they were saying it was, then there should be no confusion, because they would know Katy Perry on a shirt with some tour dates was obviously for the pop star.
Absolutely. And the question comes down to, we've got a t-shirt and it says Katie Perry. There is no reference to tour dates, there's no reference to music, there's no additional images, symbols that reference pop star Katy. Is the average consumer, because of Katy Perry's reputation, so confused by these two trademarks, would they consider that that piece of clothing is connected to the pop star? And it's no.
Exactly.
Actually, they used pop star Katy Perry's argument almost against her in that respect. They said, by 2019, the reputation was so large that confusion was almost inevitable. But that's not the case. By 2019, the average consumer knows what the pop star Katy Perry, her brand, they know how, her wording is spelt, they know her name. So it actually worked against them in the end at the High Court level, and reiterated the fact that we need to look at the specific class of goods and services that the trademark is registered at the time.
Another good point, before we wrap up, is that it's a principle of, can you create the confusion and then...
Because of your infringing act of selling merchandise.
Exactly, and then come out on top?
Absolutely. And look, the courts are always very conscious not to reward a wrongdoer, and that has clearly been considered by the High Court in this decision. So it's such a win for a smaller business or people with smaller platforms, and it's such a timely reminder of the importance of getting in fast, protecting your intellectual property, and registering that trademark as early as possible, because you don't want to be in this position of having to have these fights about international reputation. And it's such a win for the Aussie underdog.